Most defendants remain physically present when their lives fall apart in a courtroom. They hear the verdict. They absorb the sentence. They react emotionally, but they stay conscious. That is the ordinary human response to catastrophic news. The mind struggles, but the body continues to function. Yesterday, that did not happen. Yesterday, a federal defendant stood before a judge, listened to the final words of sentencing, and lost consciousness at the exact moment his future was erased. Not seconds later, not gradually, instantly. The judge had not even finished speaking when his eyes rolled back, his legs failed, and he dropped straight to the floor. I have seen defendants faint before. Panic attacks, medical episodes, emotional collapses. But I have never seen a person's body shut down at the precise instant a life sentence without parole was announced. The timing was exact, as if the brain received information it could not survive and simply disengaged. The case itself was not simple. It was an 8-week federal racketeering trial built around RICO statutes. Prosecutors alleged that the defendant ran a criminal enterprise spanning more than 15 years, involving drug trafficking, money laundering, and violence. Not isolated acts, an organization. The evidence was extensive. Wiretapped calls documented instructions. Financial records traced millions through layered shell companies. Cooperating witnesses testified to the structure of the operation and the defendant's leadership role. Physical evidence placed him at multiple crime scenes connected to enforcement and intimidation. The defense tried every standard argument: overreach, biased cooperators seeking reduced sentences, misinterpreted financial data. But the evidence was not fragmented, it was cumulative. Each piece reinforced the next. After 4 days of deliberation, the jury returned with verdicts on all 23 counts. Guilty. Every one. The clerk read them methodically. Count 1. Guilty. Count 2. Guilty. Count 3. Guilty. 23 times. The defendant did not move. He did not react. His attorneys had prepared him for this moment. Sit still. Show nothing. Preserve dignity. Save arguments for appeal. He followed that instruction perfectly. When the last verdict was read, he nodded once, almost imperceptibly. No tears, no shaking, no outburst. Anyone watching would have assumed he was holding together. And in a sense, he was. Because guilty verdicts are not the end in federal court, sentencing is where reality becomes fixed. And sentencing normally comes months later, after reports, recommendations, and arguments. Time exists between conviction and consequence. The defendant believed that time still existed. He knew the advisory guidelines: 25 to 30 years. Brutal, yes, but finite. There would be an end, a release date, a life afterward, however diminished. That possibility kept him composed. Then the judge disrupted the expected sequence. After dismissing the jury, she asked counsel to remain. She explained that she had already reviewed the pre-sentence investigation report. She had considered the statutory factors, and she was prepared to impose sentence immediately. The defense objected. They cited the defendant's right to allocution and preparation. The judge acknowledged the right, but ruled that sentencing would proceed today. That was the moment the defendant's posture changed. Not dramatically, subtly. His shoulders tensed. His breathing became shallow. His attorney leaned toward him and whispered urgently. The defendant shook his head slightly and whispered back. The defense attorney rose and placed an objection on the record. It was overruled. The judge began outlining the reasons for sentence. She spoke calmly, deliberately. She described the scale of the criminal enterprise: 15 years of narcotics distribution, financial systems designed to conceal proceeds, acts of violence used to enforce compliance and silence opposition. She identified the defendant as the leader, the decision-maker, the organizer, not a participant, the architect. She spoke about the harm caused: communities destabilized, families destroyed by addiction, victims threatened into silence, businesses coerced. Then she turned to the guidelines: 25 to 30 years. But, she explained, the guidelines are advisory, and in this case, they were insufficient. The judge explained that the guidelines did not fully account for the severity of what had occurred. The length of the enterprise, the level of control exercised, the absence of remorse, the repeated choice to continue even after law enforcement pressure increased. She cited the purposes of sentencing: punishment, deterrence, and protection of the public. As she spoke, the defendant's hands tightened around the edge of the table. His breathing became visible, rapid, shallow. His attorney placed a hand on his shoulder, steadying him, but the judge continued. She said that a sentence had to reflect the seriousness of leading a criminal organization for over a decade. It had to communicate that federal courts treat sustained, organized crime with the highest level of consequence available under law. Then, she delivered the sentence. Life in federal prison. No parole. No possibility of release. The reaction was immediate. A sharp exhalation, like air forced from the lungs. His eyes widened. Then they rolled back completely. For a brief second, his body locked in place. Then it went limp. He slid off the chair and fell straight down. His head struck the floor with a sound that echoed across the courtroom. A sound that made everyone flinch. Marshals moved instantly. One checked for a pulse. Another called for medical assistance. A third secured the area. The defense attorney dropped to his knees beside his client. The prosecutor remained standing, silent. The judge ordered the courtroom cleared. Paramedics arrived within minutes. The defendant was breathing but unresponsive. They administered oxygen, started an IV, and placed him on a stretcher. He did not regain consciousness as he was wheeled out. An hour later, the court reconvened. The judge reported that the defendant had experienced a severe vasovagal syncope, a sudden drop in heart rate and blood pressure caused by extreme stress. He had regained consciousness en route to the hospital and was being held overnight for observation. Then the judge made a critical clarification. The sentence remained in effect. The medical episode did not alter the outcome. The defense requested that sentencing be delayed so the defendant could allocute in person. The judge denied the request. The rules require the defendant to be present when sentence is imposed. He had been present. Loss of consciousness after the sentence did not invalidate it. Life without parole stood. Legally, that sentence is final in the most literal sense. Federal parole does not exist. There is no mechanism for early release. Clemency is theoretically possible, but statistically rare. The defendant will be transferred to a high-security federal penitentiary and remain there until death. That is what his body reacted to. Not prison, eternity. A 30-year sentence is measurable. There is a horizon. A life sentence is not. There is no date to count toward, no endpoint, only time passing until death. The defendant believed he had months to process, months to prepare arguments, months to say goodbye. Instead, finality arrived without warning. The defense will appeal. They will argue that the upward departure was excessive, that life without parole was disproportionate, that immediate sentencing denied preparation. Those arguments will be heard. They will almost certainly fail. Federal appellate courts grant broad discretion to sentencing judges who explain their reasoning. This judge did. Thoroughly, methodically, on the record. The sentence will stand. Appeals may take years. Habeas petitions may follow. But none of that changes the reality announced yesterday. The defendant will die in prison. What remains with me is the sound, the impact of his head hitting the floor. Because it was not staged, not calculated, not emotional theater. It was the sound of a body shutting down under the weight of absolute certainty. The punishment is not only confinement, it is the knowledge that there is no future outside those walls. That knowledge settles in slowly over years. Yesterday it arrived all at once. The judge chose to sentence immediately. Some will view that as harsh. Others will see it as efficient. The law permits it. The judge exercised that authority. My role is not to debate the choice. It is to explain the consequence. A man stood in a federal courtroom, believing he still had time. He did not. And when that reality became unavoidable, his body made the decision his mind could not. That is what life without parole sounds like when it arrives without warning.